Hey, everybody. Welcome to this week's Trump Trials and Tribulations. I am a somewhat under the weather Benjamin Wittes, joining you from the New York Bureau here with Anna Bauer from the Scott studio, fresh from his trip to the beach to visit Judge Eileen Cannon. We are joined by Roger Parloff, and from the Endless Scream Pillow Studio, it is Quinta Jurecic joining us from the Brookings Institution. Guys, we're going to start in Fulton County, which we haven't talked about for a good long time, but a bunch of things have happened down there while we all had our eyes on New York, starting with an election. This is the only case in the United States that I've ever heard of in which the voters of Fulton County get to vote for or against the judge, the prosecutor, several of the witnesses, and the defendant. So, it's a wild and woolly situation down there. And we had elections in which both Fani Willis and boy wonder Scott McAfee, judge of the Fulton County Circuit Court, District Court, were on the ballot. So, Anna, bring us up to speed. Are we going to see more of Fani Willis and Boy Wonder, or have they been tossed out of office?
They have not been tossed out of office. Both of them easily cruised through this stage of the election. There still is. This was the primary. Fani Willis still faces off against a Republican. Her name is Courtney Kramer for the general. But I think that this was likely to be, if there was going to be a challenge against Fani Willis, which I don't think anyone expected, Fani Willis's primary challenger, who was a civil rights attorney and radio host in Fulton County, to defeat her, but she easily won in this election. And her Republican challenger, Courtney Kramer, has very much been trying to platform some of the continue to talk about and platform off of the allegations against Fani Willis with respect to Nathan Wade. But I will say that we also saw this week both Fani Willis and Nathan Wade doing media appearances, which was very interesting. On the night before Fani Willis's primary race, she went on Rachel Maddow's show. There was nothing that I could tell that I think is something that, really put her in a danger zone in terms of Trump's team using it in some kind of future motion or appeal. But you do just have to wonder if that is the wisest move when you've already got a forensic misconduct appeal that is pending before the Georgia Court of Appeals, forensic misconduct related to public statements that Fani Willis has made about the case. And then also there's this narrative that Trump's team has used in which they have argued that Fani Willis has, used this case as a platform for a national political career. And then here she is going on Rachel Maddow's show. And then immediately after her appearance, tweeted out a 3-minute campaign video saying, "I just went on Rachel Maddow to launch my new campaign ad." And then the very next day, she wins her primary race. And then it was reported by Tamara Hallerman at the AJC that Nathan Wade was there at that election night party. And then the next day, Nathan Wade went on Joy Reid's show on MSNBC. He, again, was very careful to say, there's a pending appeal and I don't want to jeopardize the case. But he did make comments about Donald Trump. He was asked about comments that Trump made about him and about Fani Willis, and he said, I don't want to jeopardize the case, but also it's interesting to see that there are people who just say things for attention. He mentioned that a reckoning was coming And then he also, spoke about Judge McAfee's decision and some of the particular comments that Judge McAfee made in his order, in which he said either Nathan Wade has to resign or Fani Willis cannot continue on the case. He pointed to the odor of mendacity comment and seemed to think that that was, unnecessary. So was critical of Judge McAfee in that respect. And overall, it's just, I think really unwise for, even though he's a former prosecutor and private citizen now, the case has already, had so much discourse around this episode related to Nathan Wade. And you just have to kind of question the judgment, I think, about going on a national media show when it seems like it just is not a good idea.
Having made that criticism, Anna, is Nathan Wade or Fani Willis welcome at any time on the Lawfare Podcast?
Yes, if you're going to jeopardize the case against the former president, you should do it on the Lawfare Podcast.
That's right.
And not on MSNBC.
It is
not on ABC.
Outrageous that anybody would go and make extrajudicial comments anywhere but on the Lawfare Podcast.
Exactly.
Obviously there's we want all inappropriate extrajudicial comments to be made here. All right.
We do have one. Oh, go ahead.
No, go ahead.
Well, we do have one more actual development.
That was what I was going to ask about. Let me set the question up for you. So, Anna, did something happen today that we need to update people on?
Something just happened, and when I say it just happened, I mean it just happened like less than half an hour ago, in which I got the docket alert, and I have not yet had time to fully review because I was headed into Trump trials when this happened. But we now know that Fani Willis plans to cross appeal. But of course, keep in mind, everyone, that the background of this is that the Georgia Court of Appeals has decided to take up Trump's disqualification appeal of the order in which Judge McAfee declined to disqualify Fani Willis and instead kind of forced Nathan Wade to resign. And as a part of Georgia appellate procedure, the person who is being appealed against, in this case, the Fulton County District Attorney's Office, can then cross appeal. And we do have something that is appealable for the Fulton County District Attorney's Office. That is the order by Judge McAfee to dismiss 6 counts against, I think it was 3 counts against Trump, and then, or maybe 2 actually, 2 against Trump, and then various other counts against other individuals in the case. And that was the soliciting violation of oath of office counts. And so Judge McAfee threw those out, basically saying that the indictment was not sufficiently clear as to, which part of the oath it was that was apparently or allegedly being solicited to violate. And so Fani Willis is notified that she plans to cross appeal. So that will be interesting. I think the thinking there is just that we've already got this appeal that's going to take a very long time, and it's not going to substantially slow things down by throwing this cross appeal in. So why not? So that's where we are.
And so we don't have anything like a briefing schedule or for this, right? This is just at the stage of the court has agreed to hear it.
The court has agreed to hear it. And again, the Georgia Court of Appeals, I've said this before, but the Georgia Court of Appeals is not known to be speedy, but it seems, so we're still waiting to hear when it is that they will hear oral argument on this. And, there is a standard briefing schedule that will apply in terms of, when the parties have to submit their briefs and when the response is due and all of that. But we just don't know when it hasn't actually been assigned to a panel that we know of publicly yet. So we will see. All
right. Moving south from Fulton County, if you go pretty much due south for a lot of miles. You will eventually get to Judge Eileen Cannon's courtroom, where I hear, Roger, there was not a particular line or difficulty getting in. Let's start with, did you have to hire a line sitter to get there at 3 a.m?
No, this was a different scene. There was no Trump, of course, and there was very little, almost no hope of having a trial before election. And no, it was a different scene. Everyone that wanted to get into the courtroom could, even though it's a tiny courtroom. And there might have been about 14 people there, but reporters between, 10 in the room and 4 in the 10 in the courtroom and 4 in the overflow. I wouldn't call it overflow. It's really the bathroom room, the room where you can go to the bathroom anytime you want, because there was no need for overflow.
All right, so I want to start actually with a very important contribution to the intellectual discourse about Eileen Cannon. The estimable Professor Stephen Calabrese of the famed Calabrese law professor family, which I believe, by the way, for those who are into the history of Italian film, I believe the Calabreses are the family about which the great film The Garden of the Finzi Contini is based on that family. This gentleman, who we've sparred with a bit on Lawfare at times in the past, wrote an article saying that Eileen Cannon was a great American hero. First of all, have you read the article, and what do you think about it?
I'm afraid I didn't get past the headline. I left it there. I know this Calabrese's work, and I would say that, he's not a direct lineal line from Guido Calabrese.
He's a nephew, I think.
Yeah, and that's about all. No.
All right. So hero of the judiciary, Eileen Cannon, holds I think you told me it was a 4.5-hour hearing yesterday. What was it on? Was it on whether Donald Trump stole a bunch of classified documents and then obstructed justice rather than return them?
So we are going methodically through every motion that was filed by the defense, apparently, and holding hearings on every single one. We are up to this with the 6th and 7th. It was Waltine Nauda's motion to dismiss for selective and vindictive prosecution. That was in the morning. And in the afternoon, it was a motion to dismiss based on pleading insufficiencies. And that was joined by all defendants, but it was really written by Nauda's attorney also, Stan Woodward. The first one, which was the morning, the basis for it has changed sort of every time Woodward writes or speaks about it. This became very frustrating to the government, which David Harback was speaking to this motion, and he got worked up at one point. But this is the one that it has something to do with the theory that, one of the theories is that there was a meeting back in August of 2022, the first meeting where the government team met Nauda's then new lawyer, Stan Woodward, and they wanted to try to get him to cooperate. And they said that they were planning to indict him for his grand jury testimony, which was perjurious. Maybe not that strong, but yeah, I think that's strong. And but they also brought up said something about, well, Woodward's version of it is that they mentioned the fact that Woodward had been nominated for a judgeship.
And just for listeners who don't know this saga, Roger has a long article in Lawfare about it from, I want to say, about 3 weeks ago or so.
Yeah, a long, fascinating article.
It is an excellent article. I read every single word.
Yeah, and a superior court judgeship. And at the end, he allegedly said something like, "Don't mess it up." And so the theory was that he was implying to Woodward that unless he could get his client to flip, something bad would happen with his clerkship, with his judgeship application. Jay Bratt, who was the attorney, the National Security Division attorney that was making the remarks, said no, he'd never worked with Woodward before. He did some research, did a Google search, see who he was, saw that you can do the Google search today, Stanley Woodward, and then you'll see something about nominating commission. And you click on it, and it looks like he's on the nominating commission for Superior Court judges. And so he was sort of saying, "Oh, I see you're on the nominating commission. I see you've done blah blah blah," and he was trying to butter him up. That's his version. Anyway, so it's very disputed, and so that's part of it. And he says that the theory is that to punish Woodward, they punish Nauta, and they do that. And today and yesterday, Woodward gave a long riff he'd never put in any motions. I mean, there's been a motion, there's been a reply, and yesterday there was a new version, which was, he said, all they told me then was that they would charge him with perjury. But then when I get a target letter 2 weeks before the indictment actually comes down, they mention in the target letter for the first time obstruction of justice. I had no idea, and they don't even go ahead with perjury. And so there's a lot of, and if he had ever uttered the word obstruction, it would have made all the difference. And then we go through like 2 hours of argument. And at the end of the argument, one of the government attorneys whispers to David Harback, the government attorney handling this motion, something. Michael Thakur, I think, does it. And Harback says, "Actually, I am informed that in November of 2022, we did a search of Nauta's phone, and we gave Mr. Woodward the search warrant application, and it says on it that we're looking into obstruction of justice." And it was sort of, it was painful. But anyway, this was the main argument, but it had a lot of tangents.
And so how did Judge Cannon respond to any of this? She obviously didn't find it as painful as you did.
No. One of the surprises was when it started, Woodward sort of started by acknowledging that no court has ever granted dismissal on this theory at the pretrial stage. But then he said, "But I think what we need, so I think it's premature to grant dismissal. I think what we need is discovery."
Right.
And so
the last thing he wants is dismissal, because if he gets dismissal, that's appealable. Right. And so he wants an extended discovery period with no orders of any kind.
So he wanted an order to the prosecutor's office. He wants all communications, messages back and forth about him, basically about him and this incident. And she, was sort of asking a lot of questions like, so how would I word that? How would, she was taking it fairly seriously, although, I don't know. And then he said, and then she would say, what if there are no such documents? And he said, and Woodward said, well, then they should all give sworn statements at least. We haven't seen sworn statements. And of course, Woodward hasn't provided a sworn statement either. But and then he even talked about maybe we hold a hearing. I'm willing to take the witness stand. And Judge Cannon did seem to balk at that. She thought, well, what would that give us if we went down that rabbit hole? But she was also very concerned about something else that allegedly happened. Well, it actually did happen during that meeting. I don't think it's in dispute, is that Bratt did say something about, you're not a Trump lawyer. And I'm not sure what exactly he meant by that. I think it was meant as a compliment. And Judge Cannon was clearly very upset about that, and was talking about should comments like that be made? Is it fully consistent with the high standards of the profession?
But wait, this is in a meeting between prosecution and defense lawyers 2 years ago?
Yes. Yeah.
So what ethical rule or policy does that in any way violate?
She did not articulate, and this was not something that Woodward brought up. This was, again, something she brought up. I'm still overseeing this proceeding, ensuring professionalism. So it's not necessarily unethical, but professionalism is maintained, which is part of my job, which is why I'm asking, why do those comments have to be made? So I'm not sure where.
It's the famous Southern District of Florida have to be made standard, where a comment that doesn't have to be made is a basis for a motion to dismiss.
I think and then if I have enough time, I think the place where he lost it, Harbach, was when the judge started asking about, well, has the Office of Professional Responsibility of the DOJ made efforts to preserve evidence on this question of what happened? And then he said, for instance, to preserve statements of prosecutors or any Zoom recording that might exist. And now Harbach is saying, I told you there's no recording, and no recording exists. And I think it was then that she said, I'm going to ask you to calm down. And she misunderstood something he said, and he said, that's not true. It's not what I'm saying. It was, he was getting very upset. Nothing has been destroyed. He's really losing it with her. And because she, anyway, I'm going on and on, so I'll let you.
It's really incredible, though, because look, there are a lot of prosecutors who do a lot worse things that are alleged against them by criminal defendants across the country, and judges do not take it as seriously as this. I mean, it's really, and again, that's not to say, because I think that often judges should take claims of prosecutorial misconduct more seriously. But I mean, it's really amazing to hear you say this, Roger, knowing that this is not the type of thing that usually a judge would bother with. But my question is, what was Jay Bratt doing during all of this?
Well, he's there. He was the main guy, and he handled the other motion. Harbach was not in on this conversation. There were 4 attorneys who were, and 2 of them were present. Bratt was the one doing the talking. Thakur, who was, I don't know how to pronounce it correctly, Michael Thakur, was in on video conference. Julie Edelstein wasn't there. I mean, that wasn't at the hearing yesterday. And the 4th was Brett Reynolds. And I haven't seen him in special counsel stuff in a while. And I asked Peter Carr about that a few times, and he hasn't responded. So I think he might not be with the office anymore. I'm not sure.
All right. So what was the afternoon session about?
The afternoon was this motion to dismiss based on pleading insufficiencies. It's a very difficult motion to read. It's about 27 pages. And it's about a third of it is sort of campaign hand raising. About a third of it is saying that not is innocent, which you're not allowed to do in a motion to dismiss. You can't. How are they going to prove such and such? You can't do that. A third of it is highly technical stuff, and 2 points were actually gave me pause, which were duplicitousness, or actually they seem to pronounce it with a hard C, duplicitousness or duplicativeness. It's putting charging 2 crimes in a single count. And usually this is not fatal. If you do this, I mean, and think about it, the alternative would be to charge you with 2 separate crimes. Do you really want that? And in fact, if you do, you might run afoul of another rule called multiplicitousness, which is charging 1 crime in 2 different counts. So usually they deal with it through jury instructions or through a special verdict or even through a superseding indictment. It doesn't usually lead. It did lead to a funny, I thought, I mean, maybe for lawfare readers, listeners, exchange. Jay Bratt is not the most politic guy. And he was explaining, she didn't understand, how are you going to prove this count against Nauta? And he said, well, we're going to seek a Pinkerton charge. And a Pinkerton charge is, if somebody is charged in a conspiracy, as Nauta is, he can be liable for substantive crimes, even though he didn't personally commit them, if those substantive crimes further the conspiracy and are foreseeable. And so he said, we would ask for a Pinkerton charge. And then she responded and said, and what is your authority for the proposition that I can give a Pinkerton charge for a count that isn't a conspiracy count? And he said, Pinkerton. And I don't think he was trying to be insolent, but it did come across a little like Pinkerton. Yeah. You guys are muted now. But anyway.
Go ahead, Anna.
Well, I was going to say, and it's been pretty evident that Judge Cannon, she in particular seems to have react very strongly to Jay Bratt in particular. And perhaps it is because he's very, kind of just direct about these kinds of situations where she will ask something that he doesn't kind of, finesse the situation. David Harbach is a little bit more, he will say things in a way that she doesn't take the way that she does when Jay Bratt kind of is a little bit more.
Yeah. Now, in fairness, if it were true that he really did this thing in that meeting in August 2022, saying,
Nice judgeship you got there.
yeah. I mean, that would be a pretty bad thing. It's just very, very hard to believe that he did that after 30 years as a DOJ prosecutor in front of three other prosecutors, and all of the corroboration. If you do this search, you will see there is no indication that he is had this, assuming he did have the judge nomination was, I think, 2 years old at the time. I mean,
it's not going to happen now.
So, but but you're right. He's and actually, maybe you were there, Anna. I was reading, I think it was the March 1st hearing, and I was reading the bare record of that hearing, and there's a point where, out of the blue, she said, he is speaking, and she says to him, "Don't be sarcastic." And he says, "Judge, I would never. And I've asked other people, and they didn't know. It's not apparent from the record what was happening. Does that ring any bell for you?
I don't. I'll have to look back at it to see what the context was, but that does ring a bell. I just don't remember the context.
Yeah.
All right. So next up in Florida is what?
There were
rulings on these two matters, or are there other matters not to address?
There are. Let's see. This is 7. We've got 5 more, but and then we've got the massive motion to compel, which can be parsed into at least 8 parts, possibly 20 parts, depending on how you do that. Also, she unsealed a ton of stuff on, I guess, Tuesday, and we might be off. There might be no longer an undocketed docket. I think the last 2 motions that were on it have been unsealed, and a ton of, there's redactions from time to time, and a ton of exhibits. And among the exhibits are some interesting ones. There is the Judge Beryl Howell's ruling from March of 2023 on the attorney-client privilege stuff. And this is important because apparently Cannon is going to have to decide that motion, because that's one of their motions to dismiss is for prosecutorial misconduct and abuse of his attorney-client privilege. So this is her 87-page ruling on that. And it's pretty interesting reading. And it goes through, it's hard to tell at this point what is new, and what, but after the August 8th search, August 8th, 2022 search of Mar-a-Lago, came up with 102 more classified documents besides the 38 that were turned over in response to the subpoena, besides the, I think, 197 that were in the original batch. The government still thought there were more documents, and apparently it's unclear from the filing why the FBI didn't. I guess they didn't want to do any more searches. There was just too much of a public blowback, but they did want to get the documents, and so they got a motion to compel. And there's just months of runaround again, and then there's a motion for contempt. And finally, in December, more documents dribble in. 2 more come from a storage unit, and then but around December 15, 16, 4 more documents are found at Mar-a-Lago. So it's just quite a tale. And they had gone to great lengths to say, well, we'll do our own search of 4 out of 5 location, but we're not going to do our own search of Mar-a-Lago again because you did Mar-a-Lago. And the judge says, no, I think another search of Mar-a-Lago might be in order with covering more, and they find 4 more in his bedroom. So anyway, that's there's some interesting stuff there.
All right. We are going to spend exactly 1 word on all the events that have happened in Judge Tanya Chutkin's courtroom. Quinta Jurecic, bring us up to date with a single word on the events in the January 6th case.
Nothing has happened.
All right, on to New York. We're going to lose Anna Bauer in a minute. So Anna, you go first. Where are we, and what are you thinking about?
So we're waiting for closing arguments, which are set to happen on Tuesday. We think that they will take all day, and they may go into Wednesday as well. We're also waiting today to potentially hear about some of Justice Merchan's decisions on the proposed jury instructions. It's very unclear, again, because New York has a very weird docket system. Not everything, there's no like centralized docket. So we don't know if we're actually going to get Justice Merchan's order or decision today on what the jury charges will be. And we still have not seen the proposed jury instructions from the parties. So that's driving us a little bit crazy. But a few things that we're looking for in closing arguments, we did learn more maybe about what the parties might argue from some of those conversations around the jury instructions. One thing that I think was interesting is the causation argument. The prosecution wanted a broader definition of causation, whereas the defense wanted to keep it more narrow, and Justice Merchan seemed to want to go with the defense. So I think that we could very well hear some arguments around whether or not Trump actually caused these records to be falsified in the entries of the Trump Organization books. I think that we will hear a lot about intent, and particularly there was a lot of discussions about Trump's intent with respect to the object offense. The object offense, we now know the likely sole object offense that the prosecution is arguing is this New York election law that criminalizes a conspiracy to promote a candidate to office through unlawful means. Then those unlawful means, there's 3 theories that the prosecution wants to set out. One is campaign finance campaign finance crimes, or even civil law violations related to campaign finance. One is tax crimes, and then the other one is, and correct me if I'm wrong about this, but as I understand it, it is other falsification of records in like AMI's books, for example.
Yeah, it's AMI's books and the records that Michael Cohen created with the bank when he went to create his essential consultants, because he didn't want to say, I'm creating this LLC for the purposes of making a hush money payment.
Right. And so particularly, I think we're going to hear a lot about the FEC stuff. There was a lot of argument about definitions related to federal campaign finance. The defense wanted to really focus on, distinctions between what someone has to do to separate out, what your intent was, what were you intending to influence an election, what the irrespective rule is, all those things that I will leave it to Ben and Quinta and Roger to parse because I'm about to have to head out. But I think those are the main things: intent, causation, a lot of stuff about FEC stuff. There's still some lingering questions about whether or not the parties requested a lesser included offense on the verdict form. I'm thinking no, because it wasn't mentioned at the charge conference. And then also the New York Times has reviewed the proposed jury instructions, and there was no reporting in that report about a request for lesser included offenses. So I suspect that we probably won't see anything where the jury could come back with misdemeanors as opposed to felony falsification of business record charges. Quinta, also, we've had some discussions about the statute of limitations being told on the misdemeanor charge that is the lesser included offense. And then also there was no mention of a missing or variation of a missing witness instruction, or something in which maybe the judge might advise the jury that you can't hold Alan Weisselberg's absence against either party. So it's an open question as to whether the defense or the prosecution might mention something about, the defense didn't call Alan Weisselberg, or the prosecution didn't call Alan Weisselberg. So we'll see how that plays out, but those are the things I'm looking for in closings.
All right. So Quinta, you were in the courtroom for a couple days earlier in the week. What were your impressions?
Are we looking for impressions on the charging conference or just general impressions?
Well, I was thinking about impressions of the whole enchilada. But
Sure.
if you want to talk charging conference in particular, feel free.
No, I think Anna's description of the charging conference is great. I cannot emphasize how frustrating it was to have to listen to that without actually having the text. A reporter sitting next to me compared it to listening to an editor edit a piece out loud without having the piece in front of you. Like, it's things along the lines of, so let's look at the word willfully on page 2, paragraph 3.
Yeah, the analogy that came to mind to me was a Bible study class if you didn't have a Bible.
And had never read the Bible before.
Right.
Right. You're an alien from Mars. I have a document that has all my notes from the charging conference that's just littered with strings of question marks, bold and highlighted. So I think there's sort of not that much more we can say before we actually see the jury instructions themselves. In terms of impressions, I think I'll give a shout out to the New York trial team, Ben, Anna, and Tyler. Having gone through that grind for a mere 2 days, I'm very impressed that you all have kept it up for as long as you have, because it is a kind of a physically exhausting experience in terms of having to wake up at the crack of dawn, get there, sit in a very uncomfortable seat all day, and then do exactly the same thing the next day. I think for me, the big takeaway, I don't think there's any, particular things that I felt weren't encapsulated by the coverage that, people are missing. I think the main thing is just kind of the atmosphere of the courthouse. So if viewers or listeners have seen those sort of photos of Trump holding forth in the hallway of the courthouse after court lets out, and it looks kind of like dingy, the lighting isn't great. There's no exterior light. There are these metal barriers everywhere. That's not, the photographer using creative license to tweak with a photo. That is really what it's like. It is a kind of a worn down courthouse. It's uncomfortable. The lighting isn't good. The room is too hot or too cold. And I do think that there's something, I mentioned this kind of to complain about it, but mostly just to communicate the vibe, and also the fact that, Trump has to be there. And I think that there's something that's really interesting about that. It's not a comfortable place to hang out if you're choosing to be there. And it's not a comfortable place to hang out if you're a defendant and you have to be there. And of course, an enormous amount of people go through that system every day. There's something really striking to, watch Trump sit in that room with the bad lighting and the thermostat that doesn't quite work, and know that, he has to be there every day. That, I think, is a really striking thing, given how much he has been able to insulate himself from the consequences of his actions so far. The other things I'll just note have to do with sort of the demeanor of the people involved. I will just say, when Ben, Anna, and Tyler complain about Todd Blanche being whiny, they are not exagerating. He really is that whiny.
I was say,
I think the phrase is crying little shit.
I wasn't going to say it.
I don't complain.
And I'm quoting Michael Cohen
Yes.
there.
I whine
That's
about his being whiny.
Sorry.
I don't complain about his being whiny. I whine about his being
Yes. Well, he's right. He has this sort of fascinating mix of whiny and frat bro, which I think Ben, you also described him as. His suit is like a little bit too small. I noticed this because you see a lot of people's backs when you're in the courtroom. Emil Bovee is exactly as delightful as everyone said, although he does look like he just crawled out of a crypt. And I found the prosecution very impressive. And I think, the other figure is, of course, Justice Merchan, who I think I came away, I was in the courtroom when he lost his cool at Robert Costello, and kicked out the press. But overall, I think, he really does have this sort of quiet authority, I guess I would say, over the courtroom. He's very calm. He's very measured. You can tell he really values his ability to sort of maintain the integrity of the courtroom as a space where this trial can take place. And when people try to intrude on that, as Costello did, he pushes back. And that was interesting to kind of see him in motion, as it were.
Speaking of the incident with Mr. Costello, I am curious for your thoughts on the rather fierce press reaction to it. The press filed a letter with Justice Merchan complaining, one might say whining, about his having cleared the courtroom. On the other hand, on my Dog Shirt Daily blog the other day, a former trial judge wrote in the comments that she was very impressed with him for clearing the courtroom before he berated a witness, and that doing that, not taking a moment to not humiliate a witness in front of everybody is actually a sign of grace for which we should be thankful for. With Merchan, it's there in what he said is in the record for anybody who wants to read the transcript. So as one of the people who was actually kicked out of the room, where do you come down on this?
I will say I did not see the sort of scuffle with the press as it happened because I was sitting near the back. So I was actually one of the first people to leave the courtroom. So I'm basing this only on reporting from other folks who did see it, and the transcript. But if you look at the transcript, which I believe is now publicly available, you can see there is great outcry from members of the press, including a lawyer representing a coalition of media outlets, saying, this is a public proceeding. We have a right to be here. On what authority is the judge demanding the courtroom be cleared? And court security is really not having it. And, they essentially pushed us all out into the hallway. People kind of milled around for about 5 minutes and then they let us back in. I have to say that I am not too worked up about this. I'm much more worked up about the fact that we still don't have the proposed jury instructions. Maybe that reflects, the lawfare.
Oh my God, you are such a nerd.
Well, exactly. But I will say, I think that look, Merchan says, if you read the transcript, he basically demands that the courtroom be cleared. Once it's cleared, he says, I want to take a moment to recognize that the press was upset about this. And I want to say that, this will not be totally sealed. I'm going to have this aspect of the record made public along with the rest of the transcript. So, the press will have access to that, which I think if he had cleared the courtroom and then not included it in the record at all, I think I would feel differently. But we do have a sense of what happened, which is that he told Costello that if he continued along this route, he would hold him in contempt and would strike his full testimony. so we know what took place. We saw the interactions preceding it. So we have a sense of what the dynamics were. And so I ultimately feel like, I can understand the frustration on the part of the press. And I think there's a little bit of kind of, everyone's playing their role, right? It's the judge's role to maintain decorum in the courtroom. It's the job of the lawyer, the representing the media coalition, sort of pursuing press freedom objectives, to push back and say, on what authority are you clearing me from this courtroom? I have a right to be here. In the end, personally, I'm just not too worked up about it. I actually do. I will say, I do think that it's frustrating that we don't have the proposed jury instructions. Merchan said in a ruling, which I'm not sure when it became public, but it was
You
brought to
cannot
my attention.
possibly get Quinta off this subject. It's awesome.
No, it's important. It's he said that they should be public as a matter of public record. And I think it's really important to know how both sides are thinking about the instructions to the jury. This is the case where the jury instructions are going to be really crucial in shaping how the jury understands the case because of the sort of complicated structure of the charges. And it really hampers our ability as members of the press to describe what is going on and to explain it to the public. And I for one, I'm outraged. I'm ready to send Justice Merchan a letter of my own.
All right. We are going to go to audience questions. The first question comes from the anonymous attendee. By the way, anonymous attendee writes great questions. And I have no idea whether this is one person or like 5 people, or one person and his or her evil twin. So to whoever anonymous attendee is, show yourself sometime, be non-anonymous so we can introduce ourselves. My question pertains to both the legal and strategic aspects of formulating closing arguments. I'm curious about the legal validity and advisability of the district attorneys arguing that the falsification of business records was aimed not only at concealing the payment to Stormy Daniels, but also at masking the broader conspiracy to suppress and manipulate stories, notably through the catch and kill tactics and the planting of defamatory stories in the National Enquirer. The revelation of the details behind the Daniels payment, to my mind, would inevitably expose the entire illicit scheme orchestrated by Pecker and Trump. I strongly believe that connecting this deep, long-term illicit campaign-centered conspiracy directly to the charges would significantly influence the jury's perception of the crime's severity. What say you? Quinta, what say you?
So Ben, you should weigh in here as well, because I have not been in court every day, and I've been keeping track of it as best I can through Tyler and Anna's tweets and your all's write-ups. So, but I'm not as up to date on precisely what has been argued. I think that the DA's office has been arguing this, and the reason. So I should to back up for a moment. One of the things that we've all been discussing off camera, at sidebar, if you will, is the fact that the DA has gone through very carefully sort of establishing what Trump allegedly did, but has not gone through in as much detail walking through the relevant law. And how these things all connect up, how the business records connect to the object offenses, what the intent is to do, et cetera, et cetera. And so I think we're really waiting for that in closing arguments. And that's why it's important that we should have had the proposed jury instructions, because it would help. But moving on, I think that because of the way that the DA is arguing that the tax fraud is related to the election conspiracy, I think there has to be a connection between, not just falsifying the hush money, but as part of a larger conspiracy, because the tax fraud well postdates the election conspiracy. The election conspiracy is something that happens in 2016 before the election. The tax fraud would have come later, once Cohen had been paid this money because he didn't, register it properly on his taxes. So if you want to link the election conspiracy to the tax fraud, which Matthew Colangelo for the prosecution said during the charging conference that the prosecution wants to do, you have to kind of understand it as a sort of a broader scheme of conduct that is to some extent forward-looking at the moment when the hush money is paid. I don't know if what I said just makes any sense to anybody but me, but that is the way that I understand it. It is worth pointing out that Emile Bovy objected to that characterization and asked for the tax fraud charges to be removed entirely from the jury instructions, precisely because they postdated the election conspiracy. Long story short, we will see. I think this is something to watch very closely during closing arguments.
Yeah, I think for exactly the reason that the questioner states, which is that the prosecutors want to emphasize the seriousness of the allegations, they will do exactly as much of what the question describes, that is, linking it to this broader scheme, which they contend was a scheme for illegal election interference and influence, as they can in oral arguments. And as Quinta says, that is why the specific jury instructions, which will contour their ability to do that, matter a lot. Josh asks, what specific tranquilizer was Michael Cohen taking? And given how effective it was, why couldn't the defense get some for Robert Costello to take it? Quinta, was it Seroquel or something else? Or maybe it was ivermectin.
I will say, yes, Michael Cohen was very restrained over the course of his testimony. I was pretty surprised, actually. I was expecting some more fireworks because we know that Cohen can be, let's say, erratic in his conduct, as anyone who's listened to the recording of him berating Tim Mock, then of the Daily Beast, knows. I think that Costello, well, this is just my theory. I don't know if this is the case. I think that Costello getting up there and being pugnacious and pissing off the judge was, in its own way, maybe part of the strategy, in the sense that my theory of this is that, if you're looking at the defense's case, there's the part of the defense's case that is what you would do if you were a competent defense lawyer. And then there's the part of the defense's case that is what you do if you have a difficult client whose name is Donald Trump, who pushes you to do things like, essentially ask Stormy Daniels, what were you wearing, about experience that she's describing. And I wonder whether Costello is kind of in the second category of Trump wanting his lawyers to be more aggressive, more pugnacious, push back against the judge. We know he's been doing that. There's been New York Times reporting on the subject. And so, maybe this was kind of giving their audience what he wanted. Or maybe it wasn't. I truly do not know. But I will say that this behavior is more dramatic than I expected, but I am not surprised that Costello's testimony went poorly. Ben, you're muted.
Richard Wattenbarger, you have the next pair of questions.
Okay, so my first question is probably naive, or maybe I'm just overly credulous, but I'm really curious, actually, why a convicted felon like Cohen, who has seen the light regarding Trump's corruption, why you wouldn't actually have more credibility with the jurors. And is it dicey to rely on the jury to set aside questions of Cohen's motives for testifying, whether it's retaliation or financial gain? And also, even setting aside his unlikability, how, in terms of his credibility, does this situation differ from, for example, Watergate figures like Dean or or Colson, who was a really bad guy?
Right. So I will take a crack at this. In the case of so often cooperating witnesses are the least likable people in the world. Think of mob cases, right, where you get an underboss to testify against the higher boss, right? You're dealing with very unsavory people, and sometimes their credibility can actually flow from how bad they are, which is to say they're very candid about who they are, and their credibility kind of flows from their ease and facility with the world about which they're testifying. The problem with Cohen is not the underlying activity that he engaged in. It's that he has a history of lying, including lying under oath. And that history includes some rather recent activity, particularly if you believe him. So he now contends, or sort of contends, that he was lying when he pled guilty to some stuff. And although when he is now asked about it by the prosecution, he contends that that's not what he was saying, although if you look at what he was saying, it very clearly was. And so the problem with Cohen is that his story keeps changing, at least aspects of it do. And that makes it hard to figure out what the core of it that he's been genuinely committed to looks like, and whether to treat that core as credible. Now, I happen to think that there is a core that he's been pretty consistent about, and that's highly corroborated by a lot of records. And I think that as a result of that, a juror could very reasonably look and say, look, I'm going to tune out everything else, but the stuff that Cohen is saying about the Stormy Daniels deal, about his activity with respect to the Stormy Daniels deal, in parentheses, including about his conversations with Trump about that, and about the reimbursement, are corroborated by a gazillion records and other people's testimony, and are therefore, except on two really important points, you don't really need to rely on Cohen that much. Now, for those two important points, which is Trump's individual role, you do. And that will require the jury to, I don't know if a leap of faith is the right word to describe with respect to Cohen, but certainly a leap of something, a leap of credibility. And without that leap, there will not be a conviction. And so it is, you're asking the right question, and the defense's job is to muddy him up and dirty him up as badly as possible. And the prosecution's job is to kind of emphasize the degree of corroboration and the degree to which you don't need to believe Michael Cohen in order to believe these things. So that's that's the parameters of it. And yes, his direct involvement in the stuff does make it easier to believe him. As to the relationship between Watergate figures, Dean and Colson are not similarly situated. Dean became a cooperating witness. Colson Colson was, I don't think he pled. I think he was convicted at trial. And Dean was fiercely contested until the tapes came out. And the tapes revealed that Dean was right in almost every particular of his major testimony, including, most importantly, with respect to the cancer on the presidency conversation. And so Dean had what Cohen does not have, which is to say tapes of the critical conversations. Your next question.
Okay, in the event that the New York jury convicts Trump on the felony charge, when does the clock start for seeking an appeal, and what path through which courts would an appeal take? And what do we know about any sort of probable, what can we forecast about a probable timetable for the appeal?
All right, so I'm gonna, since Quinta has spent more time with recent New York appellate law than I have, I'm gonna let her describe the path. Generally a case becomes ripe for appeal after sentencing, which is when the case is over and the judgment is pronounced. Sentencing I have not actually tried to figure out how long sentencing would take following conviction in New York, but in the federal system, it's usually about a 12-week lag, at least in major cases. And so I think you can assume that there would be a sentencing. If there were a conviction next week or the week after, there would be a sentencing sometime in August or September, and that would start the appellate clock. The appellate clock in New York is pretty long. So if you think about the Harvey Weinstein conviction, which was just overturned in part by a mid-level appellate court, that was, what, 2 years ago? And so I may have the details of that wrong. Quinta, do you have thoughts on any of this?
I'm afraid I don't have a good sense of the timing. I do know it looks like you have 30 days to file an appeal after sentencing.
File a notice of appeal.
File a notice of appeal, sorry. Beyond that, I'm afraid I don't know. My impression is that if he were to be, just from talking to people who do practice in New York, I'm not sure about the precise timeline, but my impression is that, let's say he were to be convicted, there were to be a sentencing, he were then to appeal, that it is almost certain that it would not be resolved by the beginning of November. So it would be on appeal while people go out to vote.
All right. Jeff asks, can Merrick Garland take any steps to prevent the subversion of justice if Trump wins and declares he will order the Justice Department to drop all cases on January 20th, 2025? Roger, what do you think?
I don't think Merrick Garland can, because he will be out of office and have no standing. I think you do need to move to dismiss the government, and I guess, well, the government needs to move to dismiss, and then the judge is needs to approve that. And so if Judge Chutkan wants to fight it, she can. And we had a version of this with Michael Flynn, and it's very difficult. And it was inconclusive with Flynn, the way it played out. And when it became clear that it wasn't going to be dismissed instantly, and the Trump administration was ending, he just pardoned Flynn. But it's not I think that she would appoint an amicus or a litigating amicus or some attorney to sort of act in the role of the attorney general, but if we had, the further along this would be, it would be more feasible. If he had been convicted and not yet sentenced, there would be less for this outside party to do. If there had been a conviction and a judgment, then I don't think you can do it. I don't think the government can't just go in and say dismiss it. It really doesn't. The power of the judiciary is much greater at that point. And but if there's no conviction, the mechanics of it, how do you transfer the files, and it's hard to know how it would be possible.
It's extremely difficult to force the Justice Department to prosecute somebody it doesn't want to prosecute. There is one important caveat here, which is that technically this is being prosecuted by the special counsel's office, which cannot be interfered with without some inconvenience. The Attorney General can ultimately direct it, but might have to give an order that the special counsel would, have to defy and be removed, or there might have to be a report to Congress. At the end of the day, there's no way that these Trump cases are going to survive a second Trump presidency. Jeff also asks, what are the national security implications of a presidential candidate being a convicted felon? Will that status affect the usual courtesy intelligence briefings? Will the intelligence community take any steps to assess risk? So I don't think we know the answer to that question. First of all, he's not a convicted felon yet. I believe that at the point at which this is entirely up to the incumbent administration. There's no law on this. It is normally just a courtesy that the kind of beginning of a proto-transition, that you keep the other person who could become president briefed on basic stuff. I think there is a possibility that the intelligence community will decide not to do that. Particularly, I think less honestly because of the conviction than because of the outrageous handling of classified material that's alleged in the Mar-a-Lago case. But I don't think we really know how that's going to happen. Roger, Quinta, do you have thoughts on this?
One clarification. Formally, the president doesn't need a clearance. No,
but this is about a presidential candidate.
I'm sorry.
As in, if Trump were to be convicted.
Oh, okay. I'm sorry.
Would this affect the briefings that he's likely to get from now until the election?
Okay. Mm-hmm.
Quinta, do you have thoughts?
No, I don't think that I have anything to add there. I just note that Trump posted on Truth Social today that he was uniquely capable of talking with the Russian government to get imprisoned Wall Street Journal journalist Evan Gershkovich out of prison in Russia, which suggests some additional reasons why the intelligence community might be hesitant there.
Well, Trump would not be the first to do and say outrageous things to try to get Americans held abroad released as a theatrical show of political relevance. And I will say that if he were able to get Evan Gershkovich released, I would tip my hat to him. And I do think that for Vladimir Putin to get a message from Donald Trump that Evan Gershkovich's release is expected by American politicians of all stripes would be a very healthy thing. So of all
the Kremlin has said they're not interested.
Yes, well, I was about to say I thought his likelihood of success on on that is minimal. But I do think if, Trump wants to show himself relevant and wants to use Evan as a way to do that, that would not be a crazy thing. Kevin asks, what has the jury seen or heard in the New York court with regard to the gag order and the contempt findings? The answer is absolutely nothing. The judge's job is to protect the jury from every shred of information that isn't directly relevant to the charged offenses and that isn't evidence presented of the underlying offense. His behavior in court or surrounding the case is irrelevant to whether he's innocent or guilty of that. A related question from the anonymous attendee. Again, is this the same anonymous attendee or a different anonymous attendee? Given the composition, education level, news sources, etc. of the jury, if a jury member happens to know that Weisselberg is in Rikers for perjury, can they discuss that with other jurors if his absence comes up during deliberation? So this is a fascinating question. And I think Roger may know more about this than I do, but I think the answer is jurors are supposed to bring in their life experiences. So if you're a doctor and you find that the testimony of a medical expert is not credible based on your knowledge of the relevant medicine, that's legit. But you are not supposed to bring in evidence that is not presented in the court. So if you happen to know why a witness is not there, that is not legitimate for you to inject. If the judge had wanted the jury to know that, he would have allowed the presentation of that. Now those can be a difficult line to hew, but I believe that is the line. Roger, am I wrong?
I think I disagree with the doctor analogy. I think if a doctor has some opinion about something, that would be expert testimony his expert, that would be bringing in his expertise. I think that would be considered improper. That's not evidence. I think, here the initial screening of the jurors, I think they were read all of the names of people and they were probably asked, do you know any of these people? I guess this is maybe a separate question, whether somebody they know later told them that they know this guy's in prison. It does seem outside the case. It's not supposed to be, they would not be supposed to discuss it. But, policing these things is pretty impossible.
But jury instructions generally do say you're allowed, you
common sense.
But it's limited to common sense. It's not, I thought it was also life experience.
Life experience, but I don't think that means expertise in a, professional expertise. That would be where you would need to haul in an expert. Of course, we have two lawyers on the thing too.
Right.
What are they going to do? So, yeah.
Right, especially lawyers who know what a retainer agreement is, right, which is a relevant fact in jury adjudication of this. All right, last question. Douglas asks, perhaps I am reaching for straws, but do any of you all think that Chief Justice Roberts might react to the Alito flag flap by bending over backwards to give a better ruling in the presidential immunity appeal? I'll just speak for myself. No. Quinta?
Yeah, I doubt it. Although I will just say that I have vacationed on Long Beach Island, not in that neighborhood. And people have some weird, that is not the weirdest flag that I have seen on the Jersey Shore. That doesn't make the conduct any better, to be clear. I'm just saying, Martha Ann Alito, she's in good company.
Roger, what do you think? Are we going to get corrective action from the Supreme Court in the form of a better immunity decision?
No, I don't think so. Certainly not consciously. And I don't think even subconsciously. And of course, he shouldn't, obviously, but
I think Roberts will write the best opinion he can, assuming he's the one writing, irrespective of Alito's wife's behavior. I do also think that, it is an interesting contrast between the two of them. Alito is very carefully, seems to be cultivating this devil may care, I'll do anything, show my politics, take money from people, and Roberts is a very different animal. His whatever one thinks about his judicial philosophy or his performance of chief, his personal conduct is always exemplary, and he never does anything that embarrasses the court. That's clearly a difference in temperament and style between the two. We are going to leave it there. I'm going to let my voice rest for the next 4 days, and we will be back on Tuesday with a dispatch after closing arguments. Hey, are you watching on YouTube and thought that this was fabulous, and if only you could be like Richard and ask a question, or be like the anonymous attendee and have us read your question? And the answer is you can. All you have to do is become a material supporter of Lawfare. You can do that, and then you get to come into the inner circle where this is filmed. It's filmed in a secret inner circle room where we take questions from the audience, and there's a chat, which is called the Greek Chorus, and everybody is super fun, and you should join us. Go to lawfaremedia.org/support and become a material supporter of Lawfare there. If you just want to say thanks for doing the Trump trials coverage, you can support us with a one-time donation using our crowdsourcing campaign on GiveButter. We really appreciate all the help that people have been throwing our way through that. I want to thank everybody who has contributed to that fundraising effort. From the Lawfare Hype House in New York, and the Scont Studio in Washington, and the Brookings Endless Scream Pillow Studio, this is us signing off. Thanks for joining us.